At what point did you realize that I need to build something of my own rather than continuing to climb the traditional, partnership track that lots of lawyers still do?
I want to work where I feel I have a purpose. There's some meaning to my job. There'll be menial stuff that I have to do, but there is a bigger picture, something I can invest my time in. And I want to get something back out of this job rather than just for the weekend. A simple thing that I like to do is I always like to add a bit of humor. There's a lot of very serious things we'll do.
You founded RMOK Legal in one of the most, competitive legal markets in the world. For those who are listening and want to, launch their own consultancy, what are the first 3 practical steps that you took and made it so successful? Welcome back to the show. Today we are joined by a guest who is literally redefining what is meant to be a lawyer in 2026. Mr. Rory is a commercial and AI lawyer, the founder of RMOK Legal and co-author of the book, The AI Advantage. He spent nearly 2 years, 2 decades, in fact, navigating global technology deals, business transformations, moving from courtrooms of Dublin to the boardrooms of London. So he's acting as a fractional general counsel, and also he hosts his own podcast that's Beyond the Fine Print. So it's a pleasure to have you here, Mr. Rory.
Thank you very much. Delighted to be here. Thank you.
Right. So we'll start from a little bit of your personal journey, and I wanted to know if when you started in Dublin, focused on criminal law before moving into the high stakes world of commercial and tech law, what prompted that shift? And honestly, does a background in criminal defense help you when negotiating a multi-million-dollar tech contract?
So, yes, is the answer. Yes, it does help. My starting, I think my career started on the basis that nobody in my family had ever been in law before. So to get a training contract, we called them apprenticeships at the time, you needed to know somebody. And Ireland's a small country. It's an island nation, and it's a lot of people, and everybody's very friendly, but it's not always moving in the same circles. My father was a teacher. My mother was a homemaker with 6 children, thrown out every day just to get out of the house, get from under her feet. And so my father was teaching lots and lots of different students across his career. So we wouldn't have really moved in circles of lawyers, because you really only need a lawyer when you're in trouble or you got something major happening in your life. So we got to a stage where I was just lucky that through one connection was able to just give me a chance. In those days, you didn't get paid to be a training lawyer. It was an honor to be a trainee. And I did criminal law for about 6 years, which was defense, and I was representing people who would have been from your aggravated assault all the way through to sexual assaults, manslaughter, membership of they called them terrorist organizations. Particularly in Ireland, we had the Northern Ireland Troubles, which was the IRA, the UVF, and others.
Right.
So I would be in different types of courts, from the district all the way through to the Supreme Court, in different guises. And what I had already realized was that in a general practice firm, which was in the Garden of Ireland, beautiful location, yes, being always inundated with lots of work in the criminal space, it painted a different picture of the real world for me. And defending clients who, for all intents and purposes, they will be guilty of things. They're tricky clients themselves. But at the same time, they're very appreciative of the work that you do. And I would do also conveyancing, and I would do family law and a bit of civil litigation. There was lots of different opportunities there, but predominantly in criminal. You would then negotiate, little by little, with larger law firms who are nothing to do with criminal, because they don't do it. They just do commercial related practice. They call themselves full service firms, but they never do criminal. And every time I was negotiating contracts, they would have turn things around faster, or they would have particular arguments which I hadn't heard before. And I felt very much I was on the back foot in those negotiations. I had friends in those firms, and they were telling me I had the amazing training they get and the amazing experience, the type of clients and all that experience. And I just got very curious. And
Mm.
curiosity is my problem for my entire life, has been what I don't know won't hurt me. And I say, yeah, but I do want to know. And if it hurts me, fine, I don't care. But I really wanted to know. So I decided the only way to get into those firms is to show that you're a safe bet for them. And doing criminal law, and because those firms don't really take criminal lawyers, I had to prove I had some commercial acumen. So the only way I could do it was to do a number of diploma courses. So I finished my master's in criminal law, not criminal, it's commercial law. Then
Mm.
I did a diploma in arbitration and procedure, and then a diploma in commercial litigation and a diploma in applied finance. And all I can say to anybody, it was a great education in applied finance law, but I did leave that course knowing I didn't want to practice any subject that I learned in that course. I was just not going to be a mutuals or derivatives lawyer. I was certainly not going to be advising on pensions. So it was like, no, not for me. Thank you. And that allowed, but that did open the door for somebody to give me a chance. And that's all I needed. And then I moved into mergers and acquisitions, corporate law. From there, then I could piggyback into projects, energy and construction. So that was renewables and oil and gas and things that were unique to the Irish. But it's a very regulated, heavily regulated market. So that was a new way to understand how those things worked. And after that, then the financial crisis hit. So worldwide, everybody went, huh? And the banks went, we don't have more money. And the construction companies went, well, if you're not going to lend us money, we can't build anything. So then obviously, why do you need all these lawyers to support deals that aren't going to happen? So that was a bit of a rush to the system where you went, okay, what do I do now? And it was very fortunate for me because I left what I thought was the biggest job, the best job with the best firm ever. And it's a great firm, still is. And said, okay, so now I'm back out looking at the market. And 6 weeks later, I was sitting in a new place doing arbitration for them, slightly doing what I did before. But because of my criminal background, because of my the way you think as a criminal lawyer is slightly different, and how you deal with stressful scenarios. Also, that helped me to understand an awful lot more. And then after that, then I was given another chance and I did 2 years in that for an arbitration that was very technical, very specific, and I was the only lawyer. And then after that, went into the technology space because it was a natural shift, because the way in which you design, build a power plant or a bridge or a new road, the structures, the warranties, the kind of thought process is very similar to how you build a new piece of technology. By and large, okay, there's lots of nuances. I know people will say, no, but it's not exactly the same. Yes, I agree. But I'm just saying there are things that you can pull. So the transferable skills that we all talk about was very much there. And even though I've been jumping from one area of law to another, I've rested in this area of law for a long time now because I really enjoy it. It's always, there's always something new coming up. And like my career, I went from, I think we were talking about outsourcing an awful lot. Then we moved into automation, robotics, security. And now it's all about artificial intelligence, which I know everybody's now kind of saying it's 3 years now. Can we just find something else to talk about? But unfortunately, this year is all about agents and agentic AI. So we'll hear
Definitely. Definitely. Now we'll come to that part of your life and what you're doing right now. But coming from a family where your father is a teacher, your mother is a homemaker, I do understand the curiosity element. That is, I think, one of the strengths that you have. But at what point did you realize that I need to build something of my own rather than continuing to climb the traditional, partnership track that lots of lawyers still do?
Yes. And there's nothing wrong with that track. I think for a long time, your career is owned by your employer. I need to qualify that because a lot of people think that's strange. I think when I started off in the era with my parents' era with working that you dedicate nearly your whole life to that one company. And I think the workforce has changed, and the generations coming through after me have said, no, I want to work where I feel I have a purpose. There's some meaning to my job. There'll be menial stuff that I have to do, but there is a bigger picture, something I can invest my time in, and I want to get something back out of this job rather than just working for the weekend. That kind of, I'll just work, and then somehow have a life. But when you're a lawyer, there's not an awful lot of time for that. So you have to build it out, and that work-life separation became work-life, balance became work-life, integration became work, and a little bit of life. And I was getting to a point in my career where I said, do you know what? It's a kind of annoying that I have all these people who, they have to give you performance reviews, and they have to sit down and talk to you about what they would like for you to improve on. And it all comes from a good place. But at the same time, you're going, yeah, but I disagree. So there was a simple thing that I like to do is I always like to add a bit of humor wherever I go. Maybe it's the Irish part of me. I like to, I know we're dealing with really multi-million-dollar contracts. It's really stressful. So many moving parts. It's very pressured. And at the end of it, you will get sick and you'll need a week off work because you've suddenly all the illnesses that you've been putting off for the last few months suddenly all come together. And somebody says, well, take a holiday. And the holiday is usually just to recover from a really bad flu that you didn't think you had, but you didn't have time to have it while you were working. And I really love that stuff, even though people go, that's crazy. But yeah, it is. But I really love transactional work. But where it gets to me is when people are saying you can't have fun doing the job. I said, you can. You need to be serious. Yes, you need to be objective. Yes, you need to be ethical. Yes, you need to be what your professional body has asked you to be. That's important, yes, because we're a profession and we need to show that. What I disagree with is we can't have fun doing it. And a lot of people say, no, we do fun afterwards or at a client event or at a conference. I said, no, we can still have fun in the negotiations. Like one little, I'll say it to you and your listeners, please don't judge me for this. It was a while ago, but we did enjoy it. We were in this negotiation, it was face to face. We had about already 2 weeks of trying to agree things in the room. And if anybody knows that, when somebody says, let's put it up on the screen and draft as we go, we know that it's going to take forever to get through that process because we've got too many people thinking around the same stuff. It takes forever, but they wanted to do this. Fine, let's do this, whatever you want. And during it, we had one particular person on the other side who was notoriously difficult in the negotiations. And you had to find tricks and strategies to circumvent what was basically the computer says no person. That was all they were. And so they used to have this phrase where they said candidly. And they said, well, candidly, Rory. And candidly, and you're going, After a while, I realized that was one of their words they loved using. So when you have your laptops in front of you, and at the time we were using Skype, okay, I'm aging myself, but we were using Skype, the message came in from one of my commercial leads. That message me said, how many more times is she going to say the word candidly? I said, and you know when you're trying to keep a straight face, because you have to be very serious about it. If you suddenly laugh and they were saying something really important, you could be seen as rude and insulting. So that's straight face, keep going. I was going, that's a good point though. So actually during it, we actually had a little row, kind of, it wasn't quite a bet because there was no bets down, but we just said, I think in the next 10 minutes, she's going to say it 3 times. And then somebody said 10. And then somebody said 15, and just to have a bit of fun. So it was the problem with, when you talk about active listening, when you say you listen to understand, you listen to win. At this point, we were listening to win this little mini bet with nothing down, just idle attempt to try and keep our sanity, whilst this person was going to tell us exactly the same stuff we've heard many times before that would push us into a deadlock position where we'd have to circumvent this person. We knew what the strategy would have to be, but out of respect, you need to let the people say their bit, move on, and find something, even a sliver of hope that could create a solution to get the deal done. And so we're doing that, but we just had great fun, doing this. And at one point, one of the team did crack with a little bit of a giggle because I think they won. And of course, everybody's going, "What was that about?" I said, "Oh, sorry. There was something just out the window there. Apologies. Yes, continue." We're going, stop that. But these are the little things when you're super stressed. The good kind of stressed. You need to diffuse it with a bit of humor. And I think I got to a point where I said, you know what, I really want to be myself. I want to deliver the services that I know people would prefer me to deliver in a way that they might understand that, yes, I know my stuff, and there's a lot of very serious things we'll do, but in those rare moments we can have a bit of levity. Let's have it.
Yeah, that's really good advice actually for a lot of people. So I wanna know one more thing. You founded RMOK Legal in one of the most competitive legal markets in the world. Now, for those who are listening and want to launch their own consultancy, what were the first 3 practical steps that you took and made it so successful?
So I'm not sure if there's 3 practical steps I can do. I'll just tell you the things that I think that's looking back worked best for me. The first one was talking to the regulator. So understanding the boundaries. So what I do in England and Wales, that jurisdiction, cannot be achieved in where I originally came from, Ireland. The laws are different. The rules on practicing as a solicitor require, in England, there are certain regulated activities which I cannot do. So I wouldn't be able to do immigration, certain financial regulated activity, and there was litigation as well. There's a fourth one, which will come back to me when I don't need to, but it'll come back. But there's 4 areas which you can't. And as a result of that, then you say everything else is all fine. So I'm able to, but what I enjoy doing is contract commercial laws, business legal services. I love doing the helping people through their issues. And if we get stuck in an IP or a data protection or a security question or on anything to do with AI, I'm all over it. And then what I wanted to do was I said, okay, once you have that in place and have conversations with your regulator, don't be shy away just because they're the enforcers, also the supporters as well. And they might be the advocates for the professions wherever you are. Don't ignore them. Check it out to make sure that you set everything up correctly. So when you write your engagement terms, when your terms and conditions for services, that they are clear to the clients, your potential clients, what you can't do. And what you can't do is the next phase. Look at your network. Who would you refer this piece of work to? So I have boutique law firms that if I'm doing a large M&A transaction and I need a team of junior associates, I'll be able to use them. Now, I'll still be the front and I'll be able to use those. And then in turn, if there's a litigation or employment due diligence review that has to be conducted, they will provide that service. And then there will be the protection of their analysis as well. That will bolster up my company. And it's an agreement between us where we say, obviously, any litigation matters, I'll be continually referring it over to them. I won't be able to do anything. I have to step away. So be it. But it's a good relationship, and having other people, other consultants who I've already structured and put the contracts in place. If ever I need them or they need me for my specialist abilities or for their specialist abilities, then we can do it. So that was the second thing that I found was very useful to get in place early. And then the third one was, how do I put it politely, to get out of my own way.
Okay.
I don't think it's so true everywhere, but I think lawyers, because we've been trained to think a particular way, to be the savior of a company or the guru with all the wisdom that could ever exist, etc. And we have this sense that we cannot get something wrong. And we need, and if we are not sure, we need to add at least 10 different disclaimers to it, just to protect ourselves from that, because we need to protect the profession, protect ourselves. And we get super proud. And that, I think, is potentially a failing, because then we don't want to fail. We have to exhaust every single thinking option before we can fail. Like, I don't know about you, but sometimes in the past, you've had a difficult negotiation or a difficult conversation, even with somebody in the family, you know, and then you walk away from it and you go, okay, now could I have said that better? Could I phrase it better? Let me go through that
Yeah.
conversation again to see. And like, there's no value really in having that conversation. You're wasting your own time because they've moved on with life. You're just stuck,
Yeah, that's
you know, trying to think things through. It's different from practicing. Okay, so I'm going to ask for this, but if they say no, what are my options? That's different. That's strategy, and that's preparing for the worst, which we do.
yeah.
But I think if I was doing this one, I'd like, for example, I would have set up my sales and marketing function differently. I would have attempted my business development approach with greater scrutiny and refinement. I would have encouraged more of I encouraged use of a lot of different kind of technologies to help streamline my services so I can be far more competitive than my competitors in the Magic Circle law firms, you know, the large law firms, because what I can provide is partner level service at without the partner level overheads that they have to suffer. I can provide teams which aren't on payroll immediately. They're ad hoc or at arm's length contractor services or consultancy service contracts. You know, I can provide a service which is more appealing to the startups and the unicorns and the scale ups, which I could never do as a private practice partner because
Right.
we're naturally expensive. You know, for me to just give 10 minutes of my time just sense checking a junior member's work might be too much for a startup to pay. Which
True.
sounds absurd when I say it, because when I was in an engineering company, the daily rate for a senior design engineer who could be designing a new railway or a new runway for an airport, their day rate was my hourly rate.
Yeah. True.
And we feel super justified in that thinking. And it's an odd one. And I know I've opened a bit of a hornet's nest there, I'm just prodding it away. But it does reflect on the fact that, you know, everybody says, well, how have we changed the hourly billing, remove the hourly billing to fixed caps? How can we get commodity-based legal services? And I think that in order to get there, you have to fundamentally shift the way in which law firms are tracked and how their performance is managed. Because if their performance is against financial targets and hourly or billing time targets in a year, then they're always going to be focused on the hourly rate. They're always going to be focused on the profit margin. And if also the other part, which I find needs a bit of a change, is around the way in which we promote or secure people equity positions within law firms. You know, so a lot of people will get equity and they might get 5 to 10 years sitting in equity. There's no incentive for them to change the business model that would potentially reduce their payout during that period of time. And why is it? Because they've had zero life for up to that point. Because they've been working absolutely like dogs, if I can say that, just to get to that position. Now they've earned it. They want to enjoy it so that when they retire, they can have a life again, which they heard about or read about in newspapers, you know? So it's kind of an odd thing. And I think I've heard of a few firms across Europe that have moved away from that model. And it sounds, they know they are not making as much money as they could, but their staff retention is very high and their client retention is very high. So maybe that's the right trade-off.
Yeah. Yeah. And, what I see is nowadays when the Claude AI legal just came out, and I think there's a lot of pressure on big law that you have to move towards the fixed retainers rather than hourly billing. So I do think, and do you think that Claude AI can really change, help, get more law firms more profitable, even if they shift towards that model?
I would say at the moment the jury is out on whether it will or won't. There's different, depending on who you read and which economists you read to, there is an AI bubble, because four hallmarks of a bubble are in play. So over investment, over saturation, over leverage, over ownership. They're the four classics of a bubble. Now, whether that actually means that the dot-com bubble to the crypto bubble to the whatever, if that actually will transpire into and transfer into an actual burst of the bubble, I'm not convinced, given the heavy investment from the likes of like Amazon, Google, Meta, and others, and Microsoft, even only late last year, and into the billions. So they're heavily invested in making sure that at least the infrastructure is in place to deal with AI. When you look at the law firms for the last 3 years since the introduction of ChatGPT, and it's over 3 years now, and it's since it was launched, law firms, the larger ones, have their software developer teams in-house, and they have been creating tools either for themselves or to sell to other law firms and legal departments in order to win out in some value here. I do know that there is the mantra which I always say to people is that AI won't replace lawyers, but a lawyer using AI will. Because the time saving, if nothing else, in a reviewing of a contract or reviewing a database because of a data subject access request or an e-discovery matter, or in an M&A transaction, the ability to trawl through mountains of data in a shorter space of time is a time saver and a cost saver. Now, I say that only when you play that off by saying, but you have to accept that it won't be 100% accurate. So what is your tolerance level? You have to determine as a law firm or as a lawyer, what is it? Is it 80% and 90%? Is that what you're expecting? And where does the human come back in to provide oversight, do the checks, the auditing, to ensure you're still in line with your code of conduct, effectively, as a practicing lawyer. So I say that, so I do think that the piece of the puzzle, which I know that my own client base, I encourage them to ask is, firstly, does your legal practitioner use AI? What for? And how is that reducing my rate? Now, the answer from law firms typically is, well, because I can do it faster, it means that I won't be billing you as much time.
Right.
So they're still on the hourly billing, and they're saying, I can do it faster. And if that fixed fee is still the same, the argument is, well, inflationary pressures, cost of living crisis, my new Mercedes, it could be anything. I jest.
Yeah.
It's still fun. So don't quote me. But I do think that there is an element of struggle within law firms to change to a different model to reflect. They're saying, I can do the job faster, which allows me then, but I still need to meet my financial target. So if you've got a 6 or with some law firms, 8-hour billable in a day, which you must bill, it may not be recoverable, but you must have that as your billing amount in a day. And you're doing AI, which gets you to do the job faster. You go, okay, well, that's an added pressure and a stress on the people who say, well, that only works if my pipeline is already full or overflowing. But if it's not overflowing, then you have potential where you might be running into headcount reduction. Or what they used to say 3 years ago was, this gives us an opportunity for upskilling. And now I'm sure somebody will tell me there has been upskilling, but I don't have anybody telling me what that was. So there was a lot of people who would have spoken about it in the tech space, were saying when you move from security into AI development, you move away from consulting and you move into AI. But consulting to AI, they're not like for like. They're not the same skill sets here. So, and for lawyers, there was, I know there's a few of the big tech companies, because one major tech company had about a 20% reduction in their share price only in the last year, which has caused a huge reduction in the number of staff. and the legal
Yeah.
department and others weren't immune to that reduction. As far as I know, they went through a number of redundancy programs, which one of them was nearly 18 months long. It was quite like Damocles' sword hanging over your job, where you have to show relevance. And the whole, I think the idea was that it would encourage competition, encourage excellent improvements, and encourage new ideas through, necessity. People will come up with their own ideas, but it actually drove a lot of people into a nervous wreck. For people who, I know some of them are exceptional lawyers, but they're closing in on their 60s, and starting, even what I did, setting up your own new practice, would be alien to them. They would think, no, I don't want to do it. But I also don't want to drop out of the profession because they enjoy it.
Yeah.
Surprisingly, some lawyers do enjoy their jobs. So, and they don't want to step away, but they've got maybe 20, 30 years with one company, and now they're back out looking for something, and then ageism is there. It's all the way through. And they're saying, well, I really do want to work, but how do I do it? And also the other thing is, how do I build up my network and connections? Because if you're in a law firm, that's second nature to you. You've had to do that.
Yep.
But if you're in-house, it's that, okay, so LinkedIn, what's that? Yeah. So it takes time. But it is a huge adjustment for a lot of people. But I think AI is a blessing and a curse at the same time.
Yeah, that's true. Now, there is something I've, recently, when Claude AI legal tool dropped. You see, you've been working into this market for some time, and you've realized that even companies like CoCounsel and Ligora, their share prices got a big, hit from just one tool dropping onto them. Now, obviously, they are using the same LLMs. They were using Anthropic. Some were using ChatGPT. The problem here is when you start a startup, something like this, you've raised $1 billion on valuation. I want to know how sure a company can be that obviously these LLM companies, which are the backbone behind these softwares, they don't start competing with softwares like these, because ultimately what Claude AI can do is what CoCounsel does. So what's your take on that?
So it depends on your budget and your understanding of the technologies. So this is a question for choosing the right technology. At the beginning, it was like a mad dash for anything shiny. I call it the shiny object syndrome. We see it, oh, that's amazing. Oh, that's a dashboard. And it does all these extra things, which I never thought I needed. So let me get that. And I have to pay this much. Well, then obviously that's right. And then you get all these sales reps from all these other companies that suddenly say, we want to show you something really amazing that it does. And they say, oh, what's the price? Oh, we'll tell you that after we do the demos. Then you have to spend 30 minutes, at least, them taking you through something which you go, this isn't quite what I thought it was. You start asking them questions. They don't really have the answers because they're not lawyers, by and large. And when you get to the price point, you kind of go, well, no. And for the first year when the LM models were introduced and the new tools were coming out, I felt the price points were very much weighted in favor of those with the big budgets. So the small and medium enterprises, the small legal departments, they were all fast followers. They were waiting for the word of the mouth. Who's going to tell me that this is the tool to use? Which is the right price point. Thankfully, the year after, there was more items coming out of the market because the gold rush around AI was emerging. And then in year 3, we saw pricing leveling out amongst many of the major players, but also the new players finding ways in which to undercut that pricing model. So there's a friend of mine who does a lot of the AI literacy training to the C-suite. And she was telling me that I was telling you about the things I would look for, because a lot of people weren't asking the right questions. Where's your data being stored? What industry standards do you have in place? Are you SRA regulated, or have you even spoken to the Solicitor Regulatory Authority or your equivalency within your countries? Did you use lawyers to develop this tool rather than just consult with them after the fact through beta testing? But were they there front and center? What is your pricing model? How easy? What's your technical support model? Are you based in the States, and so I can't talk to you until the afternoon in the UK, or you're based in Australia, so we probably never get to talk to each other. So it's kind of those questions. They said, yeah, but there's one question she asked every single time at the beginning: who owns the company? I said, what do you mean? I said, well, the ownership will be the founders or the directors. I said, no, not necessarily. If they've had seed funding, then there'll be these venture capitalists that will have secured X% of ownership in the company, which means that their agreements, not that I'm saying there's anything wrong with this, but just their agreements will have a percentage return on their investment that needs to be achieved within 3 or 5 years. And that would mean that there has to be a particular price point that they must reach. There's a particular saturation of the market they must reach in order to achieve that result for them. And then when they go back, they look for Series A, B, C, D, E seed funding, and eventually majority of the company is owned by all these people who weren't the investors. They're not the founder. They're not the genius behind the tool. And then when you ask things like, what's your technical roadmap? They can't answer the question because they're thinking about the sales of the tool rather than the development of the tool. Yeah. And you'll get platitudes, of course, but it's not, it's like we're thinking about, and we're always open to feedback. We welcome all your ideas. And what do you think? And this is amazing. And we can give you 10% off, blah, blah. And you go, okay, yeah, sure. But the result is, my concern is that anybody who is, their ownership is too much weighted in favor of these investors means that they might not be in existence in a few years' time if they can't meet that. They'll get subsumed by somebody else, bought out by somebody else, or whatever. And that means that your price, that means that as a user, I'll have to then transition to a new contract with and I need to know that it's just as easy as switching electricity provider or switching banks. It needs to be that simple. And after you've been using a piece of technology for a long time, moving to something else might not be as easy because the data migration itself alone could be super complicated and costly. And then training up the staff and doing change management and behavior management as part of that can be like a 6-month job sometimes, depending on the complexity of the data. And if you're using also a training model, which is where they're pushing us to, you'll have to start from scratch, in theory.
Yeah, definitely.
So these are the things which I kind of say, but if you're going to invest, eyes wide open, negotiate the price, absolutely. And also start with do I really need it? Because there's sometimes, somebody was talking to me about a tool that will be able to organize, their team's workflow. And I said, okay, so case management or contract delivery management tools. I said, yeah. I said, okay, but you use Microsoft. I'm not flagging anybody for any reason. It's just Microsoft is commonly used where I've worked. And they said, so Microsoft, that's great. And you use Teams? Yeah. Do you ever use Planner? They go, what? So sometimes I tell people, have you utilized everything that you've already purchased?
Yeah. Before
start going off to look for the shinier thing, because you could create confidentiality issues, data protection issues, security issues. I know that they're under pressure to show value, but I always say, with taking this tool, what is your success metric for the tool? What's the return on investment that you're expecting to see? So is it that you're going to reduce contract lifecycle by 20%? One person who reduced it by 40% recently and should be massively applauded for it. And I said, okay, and then after that, what are you going to show? Because this year, the C-suite is happy with 40% reduction. Then what? And so you still got to pay for it. Now it's a cost rather than an efficiency driver. It now becomes a cost. So what are you going to do? And also, if you're going to have automated decision-making within the tool itself, or some kind of even tacit decision-making, what oversight are you, and how will you be able to unpick it? And if there's like somebody said, oh, we've got 10,000 contracts in a month, and we've got now a self-service tool for our sales teams. We've locked down all these other things, but they can fill in the blanks in these things. Okay, that's fine. And so that's AI. I said, that's not AI, that's automation. Great.
Yeah.
So now we're going to use AI tools, which is like a chat function that you pump in a bit of information. It suggests wording that you should write, and it suggests how to fill it out. It can answer questions that you might have as about certain areas of the contract. I said, okay. And this has all been pre-vetted by the legal department. Yes, initially, and then after that it will learn. I said, and how do you know that you're not getting a bad contract drafted?
Yeah.
And at what point do you step back in to catch those? He said, well, it's only going to be a handful. I said, okay, but it could be the handful of the most expensive ones, or a handful of the least risky, and if you're willing to take that risk, because it is a commercial risk, not just a legal risk, but if it's a commercial risk that you're willing to do, okay, but you still have your code of conduct as a professional lawyer to stand by. So you need to be sure that you have done everything you could, and that you can peer into the algorithm at some point and say, it went wrong on the 5th of October. So we need to go back to the version on the 4th of October. And this is the extra data that we need to feed in to bring it up to date, but without that bad data that we had trained it on. And that might be a solution, but that kind of thinking isn't always in every lawyer's mind, because they say, well, that's an IT issue. You know, it's not for us. I said, well, actually it is, because if your regulator comes knocking, you could lose your practice certificate on the basis that you're giving out bad advice. And said, but it's not me giving the advice. Yes, it is. AI is not sentient. Not yet.
Exactly. So
You know,
nice.
like maybe with quantum computing, we might get something different. But anyway, that seems to be another buzzword for this year. But anyway.
Yeah, I guess. So, I have talked to so many lawyers, and I work in the same industry. And a lot of times when we are talking to lawyers, they always are, like you said, they are running after shiny objects, right? That's a syndrome that you've discussed as well. Why don't, like you said, big law, they do have the resources to build whole IT teams within their own practices. But mid-sized firms, why don't they go towards a custom software for themselves rather than chasing after one SaaS and then another SaaS and then gluing them together? What is really stopping them to build a tool that they need rather than, just renting out SaaS, and so many SaaS that are coming out every single day?
Can't say I have an absolute answer on this. I would suggest that it's time. It's time pressure. So lawyers typically will be very comfortable within their space, but when you're asking them to move outside their space, they hesitate, and then they want all the details, all the information. And if we get too much information, or start procrastinating, and then committees are formed, and then you know what happens when a committee is formed, nothing gets done.
Yeah.
So we comfort ourselves that we have a strong governance and committees and people on the right committees in the right times. We set up everything else. I tend to imagine this a little bit like my revision schedule when I was in university. You start at the beginning of a year. You said, right, okay, there's 4 questions in each paper. That's fine. So I'm going to study 12 areas. I'm going to cover this one in each month. I'm going to make sure I've got these kinds of notes with highlighters and tags and color coded and extra notes. Month 2 comes along saying, okay, so I didn't achieve any of that. So let me just reduce that from 12 to 10. Okay, that's fine. And by the time you get closer to the exam, obviously not you, but unfortunately for me, I had too much of a good time in university that I tended to say, okay, so I know all this stuff, but now we're down to 5 questions. I'm going to have to cram this all in very quickly, and I don't need to make it all look pretty. I just need to get the answers right. The wrong way of obviously studying anything anyway. But thankfully, I passed with flying colours, but to the shock of my parents. But that was the kind of, it's the way we do it. But I feel there's a struggle within the mid-sized firms is because there's a cost to it. And because SaaS and cloud services has been understood as being an easy, just switch it on, switch it off. So why don't we just switch it on, switch it off, test it out? I've got a lot of people over the line in my client base by saying, just call it a pilot. Just get a small team, right? Which team would benefit most from it? Usually it's like start with the litigation team. and ask them to look. If you've got a technology team, yes, use those because we're all geeks and we're nerds, whatever we're allowed to call ourselves. But we're just naturally curious about the technology, so we can perhaps talk to the software developer or the technician on the support side of the tool and understand where they're coming from, and also we're more alive to the data concerns than other people would be. But if you give it to litigation and say, okay, so you go off and look at it and test it out and get, say, 1 or 2 projects, have them in on a short-term basis, get them to use it for a short, get an on-prem solution or a ring-fence guardrail solution that you can do, and then off they go. Then they can see what works, what doesn't work. And then after that, then say, okay, did you need all these things? If you were now going to create something yourself, what would you want it to do? What would you want it to solve? And then we can see, is there something off the shelf that we can purchase? Or does it have to be actually customized to our requirements, customized or configured for the purpose of what we need it for? And then, because a lot of tools would say, well, you need this. We can give you all these things. And that's great. But then you drill into the price and you said, yes. But once you go over this amount of storage, then you have to pay this price. And then over that storage, you have to pay that price. And you go, it's a bit like buying your mobile phone. You said, do I need 200 gigabytes or 500 gigabytes? I feel like I might need 500 gigabytes. And said, well, check your phone. What do you use right now? Oh, 100. Okay. So do you really need, 200 would be fine for you. I said, I know, but it sounds bigger and better. No, bigger and better isn't the same thing. It just means more expense. And you can't, and then when people start looking at why are we spending so much money here, here, and here, we can say, but we still need the staff. They said, well, we can't afford the staff. So something has to give. That's not the conversation you want to be in. You want to change yourself. Don't let others change you. That goes for a lot of things. But I've seen departments that have been instructed to reduce headcount, even though that wasn't the right decision. And they were like, even during financial crisis, I remember there was a law firm in the south of Ireland, and please God, nobody ever does this ever again. They turned to all the trainees. They had 6 trainees for the business, and they said, so we can only afford 3, or everybody has to take a pay cut. So we're going to leave you all to decide yourself what you want to do. We'll come back in an hour. Horrific. Horrific.
Insane. Yeah.
But these things happen. And this was in the lovely, happy country of Ireland, friendly country of Ireland that we have. But we have those characters as well that exist that think that that's actually the right way to treat people. But it's these kinds of, I always say that if you're ahead of the game, you have your business plan in place, whether you're an in-house counsel or a sole practitioner, whatever it is, once you got that in place, then you've at least got a path that's aligned to the strategy of the company, not aligned to your belief of what the strategy of the company should be. You have to make yourself aligned to what they're looking to do. And if these tools make sense to enhance your cost efficiencies or your time efficiencies or quality of work, then yes, go ahead, do it. There was one client I had on a procurement exercise who was super excited about this trading platform, who would give them particular reporting that would solve about 2 days' work of reporting to the board in advance of board meetings. And it was an impressive tool. Team were based out in the Cayman Islands. I also automatically thought of John Grisham books and like the Firm and all that. But I'm sure they're legit. And the simple question that I was looking through, they were saying they were so obsessed with what it could achieve. But then, because I was coming cold to this, I just asked a few questions. And one of the questions was, so how many staff do you have to support this technology? And they said, well, it's the 2 of us right now, but we will plan to expand. I said, okay. So what's your business continuity disaster recovery if both of you are sick at the same time? And they went, why are you asking that? I said, well, we've just come out of the pandemic. So sorry to mention it, but kind of have to. If both of you were down and it was the worst one and you were out for 2 weeks, and we are using a trading platform which is live, instant, and we need to create a report based on the latest information, and you're not around and we can't deliver the report to the board, who are people that basically live on airplanes. They're always going from to somewhere in the world because they're so busy. The last thing we can say is that, well, you're not available because you don't have a backup plan. So once I asked the question, my own client said, well, we can't go ahead with this tool. They were really disappointed because they thought it would be something they needed. But by asking the questions and testing, doing the right due diligence, you'll be able to see where it's going to lead you to. It's a tangent that I always mention wherever I can, just to ask people just to. It's shiny, but it might be a car that is shiny and has four wheels, and it looks amazing. But if you lift the hood, with American terminology, but if you lift it up and look underneath and there's no engine, then what's the point?
Obviously.
Yeah.
Obviously.
Yeah. You can just put it in a garage and pretend. Yes, of course.
Yeah. There you have the best car, but it won't work.
Yeah, you got 20 amazing cars. You can never drive them.
Yeah, exactly. So in that sense, nowadays, this year, people are saying this year is all about agentic AI, right? And, about the open claw thing, a lot of people are using, it's going rampant sometimes, it's hallucinating sometimes, it's also leaking data, sometimes amazingly working for a lot of people actually. So the point here is for lawyers who generally need to follow some sort of ethics, right? And it's a very compliance heavy industry. Do you think a person like you, who is a fractional, general counsel, do lawyers really need to understand how they work? Because a lot of people I talk to, they don't even know what is prompt injection. And agents, when they run wild, they can get injected by different sources. So if you're using an agent on checking your emails, somebody can send you a phishing email and it can be injected. And even Sam Altman has said that this is a problem we haven't been able to fix. Yeah. Now, how important for a law firm is to have someone like you to tell them that, okay, this is the good software and this is the bad software, this is a good agent or a bad agent, because they might not know exactly where the injection is coming from.
So I'm still a lawyer, so I don't know the technology. I should have trained in computer science, but hey, I was more opinionated, so law was the best place for me to be. Looking at the agent mantra this year, because yes, it's being pushed heavily by a lot of people. I would say the first thing, so I wouldn't say which technology works and doesn't. I actually have to start with the basis. Should you have agents at all, especially for provision of legal services? So I will say that if you're providing legal services, I have yet to see an agent. I'm sure somebody's going to message me after this and say they have it, and all that. And I'm open to being corrected, absolutely. But I've never seen an agent where I would trust that it would be allowed to autonomously provide a legal advice. I'm happy using AI tools that will create a first draft or a suggestion on a piece of factual, position on laws. Like sometimes most recently I had to look up the laws of data protection in Singapore. And then I was also looking at something in Vietnam and comparing the two. Am I a lawyer for any of those jurisdictions? No. And I would not be entitled to practice the law in those jurisdictions either. But you need an answer quickly, which you don't have to go off and spending 2,000-3,000 from a law firm to come back to you with an answer you can get from a more advanced Google search, effectively through Gemini, Copilot, or one of the others. Where problem I have with agentic AI, or at least AI agents, is that if it's for the operational side rather than the advisory side, there is use cases that merit exploring. Yes. I would caution people, because a friend of mine 2 weeks ago, we were chatting. They were telling me the story that they had created an AI agent for just scheduling and managing the diary. And they really enjoyed it. It was very good. It was kept them on track. And it gave it an instruction to say, I have to be in this location for this client meeting. Can you set me up with a reservation at a good restaurant near this hotel that I'm staying at?
Mm.
And the agent went off and had a look around. It went straight into the web page to look at a few of the reservation sites for what's good in the area, etc. Located something. The site wasn't working to complete the transaction. So the agent took it upon itself to find a way to call the restaurant. So it had to first do a script. So it created the script that it would call to make a reservation. It then put that text to voice application. So it had to subscribe to a AI tool that would do this for them, which also meant it had to enter in financial details, credit card information of this individual. It set up the subscription, created the voice through one of their automated voice activations, and made the call and did reserve the booking based on all of this and put it into the diary. So when the person comes back to have a look to say, oh, I've got the reservation, it's all booked, that's great.
Yeah.
He didn't know until later on that he had a subscription to a new service that he hadn't expected to be paying for, and didn't realize that somebody was going to try and mimic something and create like voice cloning of sorts. It's not, it could have got worse. They could have gone off and cloned his own voice and then made that call on their behalf. But this is the question of how much autonomy you're giving to it. How much information does it have access to? I love your point about the potential of it going awry. I really like that. And this year, especially in litigation, talk to any barrister, deep fakes is on the agenda. It was only just a week ago when I think X got a call from a regulator in their Paris office around inappropriate deep fakes. And you understand what I say about super inappropriate deep fakes. But the point is that we have these agents, which I always say, if you're automating a process that's very different to giving them autonomy to go off and do things just because they saw you do it one way before, they learned how you did it before, that might not have been the most efficient way. So then they come up with another way to make it even more efficient based on what data, against what data points are they're believing that's the case. And if you haven't put the guardrails in place, then you're in trouble, potentially. But my concern was like, where did they get the credit card information?
Yeah, that's something, because obviously if you do not put guardrails and you're not techie enough, you don't know. But then there's another problem, right? And I think like pandemic, there were a lot of problems with a lot of people not learning through that time zone. And then you had a lot of people not skilled enough after, we're seeing that now. One thing that I wanted to share with you was that back in 2022, when ChatGPT hit, right? So I was running a custom development firm. I still do. So I was like, wow, this is something amazing. I could really replace my junior developers because they would make a lot of mistakes, right? And eventually we did not hire anybody new, right? And there were few underperformant. We felt like, okay, this guy is not working, we should let him go. But then I felt like in 3 years, the agents that we use are not really improving on a scale that we hoped they would, right? And what has happened is that I had to rehire all those people that I replaced. Some of them I rehired, some of them new, because you see, senior developers can review the code, but if senior developers retire, they haven't actually transferred that knowledge to the junior ones. And if we don't hire the junior ones, there's going to be a big deficit in the knowledge that we're going to get at the end. So speaking about that in law aspect, right? So if law firms think that agents can do a lot of junior work, they don't hire them. And obviously, like you said, a lot of lawyers want to retire. Some of them love their job, they don't. But eventually, don't you think that's a big issue? That's down the line, maybe in 5 years or 10 years, we're going to see a lot of people coming out of law schools might not be even, good enough to verify what AI is outputting in that sense.
Yeah, which comes down to who's leading, the tool or the lawyer. And that's the risk, is that the tool can tell you what the law is, but it might not be. I think I've had a conversation with a few professors in the universities in London, and also I met with former professors for Harvard and Miami. And because I have that same curiosity about, well, what are the universities and law schools doing to prepare for the future look and feel of a lawyer and the way in which we would deliver services. Because my view is that the level at which we expect them to exit law school is now a lot higher, because the way in which we traditionally trained lawyers was through like nearly osmosis. They sit beside you in the same office and they hear you negotiating and they hear you talking, and then you can bounce ideas around, was this right in the area of the law? Is it phrased this way or that? And you learn a lot more because you're really activating the critical thinking element of being a lawyer. And when we brought in technology like headsets, it meant that they didn't hear dialogue. They heard a one-way conversation. So they never heard how you might navigate or persuade a client to a position, but they might not be hearing you well, and you might say, no, I think that's going to cost you a lot of money. And it's no good to be, I told you so territory. Client's never going to thank you for that. So you need to find a way to help them understand your position. And if they still want to go down the path, they go down the path. But if the junior lawyer doesn't hear this, they just hear us being difficult. They don't hear the other side going, this is why, or this is how we're trying to persuade. Because a lot of law is about persuasion, rather than the black letter law itself. And so what I think is interesting is that they are looking at that. They said that they can't necessarily train them on any particular AI tool because the tools are always changing. And they also can't give gravitas to one over another. That's problematic. So it's a bit like product placement in movies. So so the issue then became, well, what do we do? So you need to up the standard. The amount of knowledge you need to learn. They'll need to learn a lot more around how to be a lawyer in your first 2 years, perhaps 3 years. And then they start running at the 3-year mark rather than at the 0 mark, in a sense. I think that there's also elements that I've said is that the osmosis, the kind of passing down of the knowledge, that reminds me of what I like to call the left side, right side brain piece. So the left side of the brain is the logical part, doing the calculations, finding the facts, correlating the facts, reading the email threads, and giving you a summary, blah, blah, blah. That's the left side. And the tools can do that a lot faster than a human being. As a lawyer, you need to do critical thinking. So that's the right side of the brain. So that's the part which you need to come up with some solutions. It's kind of software developers to say, so like AI tools are only as good as the data you feed it. And no sooner have you fed it, it's out of date. So I described it in the book you mentioned. I described that, which I co-authored with lots of other people, but I described my elements as skyscrapers on quicksand. So the skyscraper is the tool, is this amazing outputs that you're getting for, but the quicksand's the data. And you're always going to have to feed that with more sand, more sand, more sand, in order to ensure that you're up to date with quality data, not just synthetic or anonymized data or aggregated data or statistical data, etc. Everybody has lots of terminology for lots of different types of data, but ultimately, is it good data that you're feeding it? And what was, like in law, what was appropriate 10 years ago is not appropriate today in some instances. Like if you're talking about probate and succession law and estate planning, in Ireland, like the legislation goes back to 1965, so nothing much has happened since then, apparently. But anyway, the law is good. I think that's the better way of describing it. But if we look at technology, it was only in the last few years, 3 years ago, we brought in LLMs. And just that was brought in just a few weeks before the new EU Artificial Intelligence Act was coming into play. And there was a scramble at European level to try and say, are we still good? Are we still good on this? At the time, they were only thinking about biometrics. But then they said, we need to talk about generative AI, which then you had to educate legislators suddenly and regulators suddenly to see, are we still within the boundaries of our risk profile metrics under the AI Act? Do we have any guidance? Do we know enough to give guidance? there was a lot of that going on. So there was a chance that that piece of legislation wouldn't have come through at that time because of all the changes they had to do to deal with this new piece of technology that was taking off at exponential rate. So I would say that the lawyers of the future won't be, they're well placed to take on AI because they've lived and breathed technology since birth.
Yeah.
So there is,
Yeah, that's true.
so they've nothing about it. I think the workforce of tomorrow, the way in which we deliver services are changing, which also demands the use of AI. They expect the use of AI tools in what they're delivering themselves. And I can see the advantages and I think that over time, the technology will advance to a point where we can trust it. I say that because I remember when the internet came in, I'm really aging myself, but you go into a court and the judge would not accept a copy of emails as a form of proof. It's not evidence. They wouldn't accept it because it could have been sent by somebody else's terminal. How do you know it's sent by them? Just because they have an email address there, could be somebody completely different. How do we know the timestamp is right? IP, is that that's intellectual property? No, it's a protocol address. They wouldn't accept it. Like if you came up with a piece of legislation and you have to present, you submit it into court saying it's section 5 of a piece of legislation of this act, and you'd have to submit a physical copy of the act. And you say, but you can't print it out. It has to come from a special source authorized by a special government office with the print on it. And usually we'd say, can we have that back when you're finished, Judge? So I can use it for my next few other cases. But if we printed it from one of the online resources, oh no, I can't do that. What happens if they uploaded it wrong? They didn't accept it. And now, nobody bats an eyelid if it's an email as a form of proof of a written contract. Like valuable, binding, enforceable contract can be created through email. And that was before we brought in e-signatures. So it's taken time for everything to address only because we've been teasing it. Like when we came out with ChatGPT, it was banned, suspended in Italy for a few months because the regulators said, yeah, you're breaching data protection because personal data of one person is being shown to somebody else. That's the reason why when DeepSeek came out, the regulators said, hold on, can we assess this? Because we want to make sure everything's good. It's nothing to do with it coming from China. It's just because it's a new piece of technology which we need to ensure stacks up and stands in the face of the EU's GDPR. And people learn from it. Intellectual property. How many cases are going around the world right now, especially in the States, around who owns the output of the AI models? Online safety, child data protection, age gating, using AI tools for age gating as well, for age assurances against certain tools. Social media has also changed. You've got Grok on Twitter. You've got, Gemini for Google. We used to have SEO. Now is it correct? AEO? Is that what we're calling it now?
Yeah.
So
AEO and GEO, yeah.
So we're evolving into all these new branches. And everybody's running at pace, and the lawyers are sitting there going, don't forget, we're on board, we support you, but maybe we should think about a few of the risks along the way. The biggest ones, because everything is changing across lots of countries around the world now is changing, and there are laws to accommodate artificial intelligence in the machine learning, generative AI context. Some are taking longer than others, but look at China, Japan, many of the states in the US, they're catching up. They've got certain provisions across the UK. You've got the EU AI Act, and I'm missing a ton more along the way. So where people are either trying to squeeze their existing laws around the technology, which is also appropriate, or they're saying, okay, there's a few gaps, and we'll focus on the gaps because we don't have time to focus on everything else. So everything is changing, but lawmakers are always behind. So that means that lawyers need to at least try and predict rather than react to these technological changes. It's hard, but it's fun too, by the way.
Yeah, definitely. So, Rory, this has been an incredibly grounded and insightful. I loved your humor, the way you explained everything. However, I need to know one more thing. I know you have the book, The AI Advantage. Where people can get that? First one. And I'd love to have it and I want to read it. So if you could provide the links for the audience, they
Sure.
can actually download it. Yeah.
Sure. As I said to my mother, if she's wants something to set her off to sleep quickly, I'll send her a copy. Um,
I'm not sure. I'm not sure that would be the case, but I'll definitely give it a read. And fantastic having you on the show. And I hope that with all these insights, we might again call you in,
very happy
and
to. Yeah.
have all your yeah.
Very happy to. And thank you very
Thanks.
much for inviting me. It's been a real pleasure.
Yeah, so we'll put the links in the description. And thanks for listening, everyone. Have a nice day.